Allison Feldman, the victim in this case, and taken a decade to get here. But the twists and turns, even just today, where two very different set of circumstances and stories where prosecutors have really gone hard with the evidence and where that mounts to. But the defense coming in and saying, you've got the wrong guy. It's someone else, and introduced a new person that they're saying committed the crime, a pharmacist, apparently. They said that had ties to Miss Feldman. But again, just kind of out of nowhere. And we had a little bit of break there. I believe juror number 6 had his eyes closed, may have possibly fallen asleep.
Been there, done that.
Yes. And they were getting up and going a little bit, but I believe that we will have the first witness going today.
And this is why we do the trials, really, right? Because, the prosecution, I thought, came out strong and listed all of the evidence that they plan to go over during the trial. And at the end of their opening arguments, you're like, yeah, okay, sounds like they got a lot. Then the defense comes up and they just immediately out of the gate say, you got the wrong guy. This is the guy you should be looking at. Named his name, said where he works, said all these connections he allegedly had to the victim, and you're like, whoa. And then they started taking shots at DNA and how it's maybe not so solid as you think, like a fingerprint like you see on TV and movies. So there's a lot to unpack here, and we got a couple of experts to help us get through this.
And just for clarity, for folks watching, we're not going to name the person that was mentioned in court because, again, they haven't been charged with a crime. So we're going to let the attorneys work that out, and the court certainly sort out what happened, what didn't happen. But let's bring in expert we're really excited to talk to, Judge Mel McDonald. Judge, how are you this afternoon? And please, if you can give us your read, what you've been watching all morning long.
Yes, I watched both the opening and both the state and the defense. I thought they both did exceptional jobs. I thought the prosecutor did a magnificent job of laying out her presentation and the evidence. The defense did what they need to do to hopefully try to raise reasonable doubt. And as you've noted, I thought it was an interesting twist that they're trying to point the finger to somebody else. And that could very easily backfire. You've got to believe that that person they pointed the finger at will be a prosecution witness. And I think a prosecutor may well say that there's now been a second victim in this case, the gal that was murdered and the innocent person who he is now accused.
Judge, good point. We hear a lot about discovery, and you think it goes from the prosecution needs to tell the defense what evidence they have. Did the prosecution know that they were going to out this guy so early, do you think?
I've got to believe that they did. Otherwise, I think the prosecutor would be up and shouting. There are indications from what I heard in the opening statement that people had referred to this person that worked at the pharmacy. So I've got to believe that they have investigated that case. They've undoubtedly taken DNA swabs of the pharmacist, have excluded him from the evidence that was found at the scene of the murder. And so I don't know the extent to which they have the information, but I've got to believe they've known about this. They knew that he was going to try to point the finger of somebody else. And that has a great potential for backfire.
Can you hear me okay? I think my audio kind of dipped out there. But Judge, if we could real quick, I know that you've been looking extensively into familial DNA, also the DNA in this case and how it was collected with his prior arrest with the DWI that I believe was 3 years before Miss Feldman was murdered. And like we had mentioned before, this went all the way to the Arizona Supreme Court where they did rule that it was admissible. But can you tell us your opinion on that, of where the high court ruled, and then also split the difference on where would be circumstances where it would not be admissible based on where things were?
Yeah, this case actually was petitioned to the United States Supreme Court, which denied review. There have been division in the circuits over whether there's got to be an active investigation at the time they run this familial DNA. I will tell you, when I was a prosecutor in the 1970s, I was involved in two of the most high-profile, notorious rape cases at that time in Arizona history. One of those cases, we used what they called neutron activation analysis. DNA is remarkable. Oftentimes, witnesses can make mistakes on ID, but DNA is some of the most powerful, potent evidence that's out there today. Familial DNA is something that's developed where you can actually get DNA of a family member, and it's not the person, but you know that it's a relative of the person. In this case, there was either two brothers and three children possible. And they took this DUI sample from 2016 and connected ion to this DNA. That by far is the most compelling evidence. I think one other thing, there's been a lot of talk about, well, what's the motive? I think from what I've seen, the sexual assault is a clear motive, the brutal violence, the theft of money, the payments of money. No, we don't have something in writing. He wasn't caught at the scene. But you have all these bits and pieces that you put into a puzzle to say, is there enough to show that this likelihood beyond a reasonable doubt that this is the individual that did it? And I think there's, from what I've heard thus far, they've got some very compelling evidence. That DNA is absolutely critical. And yeah, they tried to diminish it. The defense attorney says, well, you can get a speck here and there, but it was the different locations that they found it in the house, and a statement from him that he had never been in the house. It's the problem they're facing is how are you going to explain that DNA getting to different points inside the house where you've never been? And then when you add to that the monies that were deposited, the vehicle at the scene, they've got a fairly compelling case going forward, the prosecution.
This DNA stuff, Your Honor, is so powerful now, but clearly people were being prosecuted for crimes like this way before DNA showed up. So does it somehow diminish circumstantial evidence now? And the jury's like, okay, his car, his ATM, whatever, but I want to see the science. Is that where we're at?
I think DNA evidence is probably the strongest component in this case and in all cases. And again, it's because of the reliability, the certainty that you can specifically identify that person, that is his DNA. My DNA, of the billions of people on the earth, there's only one person that has my DNA. And if I left that DNA in a grocery store or in a car, I have been in that car, and they can, if they've got a way to locate it and to identify it, and then now what they do is people convicted of felonies, they've got to have their DNA put in the system. It's able to identify, to answer questions, so you're not relying on ID where people might be mistaken or there's similar appearances. You've got something that science that says that person, part of that person's body, that physical makeup was in that house, and in this instance, at different locations of that house. That is compelling.
Judge, I want to ask you too, just a follow up with that, where as a defense attorney, why even bring up the other man in this case? I know that they did mention also that they had taken a buccal swab of this person originally, but there was no claim whatsoever that the DNA found in the house was tied to this person. But I'm just curious, just as a legal strategy of, you kind of mentioned that they gave out that, hey, DNA might be everywhere, the particles and how small this can be. But you just laid out a very compelling part that, hey, if it's not directly in the house, on her body, etc., as Ian Mitcham is apparently was, why bring him up in the first place?
Well, the defense's role is to try to create a reasonable doubt. Oftentimes, they won't have any put on any evidence and say the state simply didn't prove their case. Other times they'll try to point little bits and pieces. In this case, there's obviously some information. Apparently, neighbors or associates provided information about this other person that prompted an investigation, that prompted suspicions. What you're trying to do is to say, when you're in the jury room, you're looking at a death penalty case. Here's this information. Here's this other person. And it's a gamble, but it's also a very positive thing. They've identified the person. He's undoubtedly going to have to take the witness stand. And remember, what you're trying to do is to get one juror. Now, one jury only hangs the case if they can vote a not guilty, and then you got to retry the whole case again. But if they can create compelling evidence, information that might cause a juror to think, well, you know, somehow maybe somebody else came in there, was with this guy earlier, brushed against something in the house, who knows what. The problem that the defense is going to always have is the DNA found at different locations, the deposit of money, the car at the scene. These are all very compelling pieces. If you're the defense attorney, I'm trying to raise reasonable doubt. If you've got somebody that other people said, look at this guy, and there's suspicious activity, if he's gone to this girl's website, or if she was a customer at the store, these are all things that you put in the juror's mind to say, gee, maybe he did do it. Do we know beyond a reasonable doubt that Ian did this? And that's what you're trying to accomplish as a defense attorney.
Your Honor, hold on for a little bit longer, if you don't mind. We have a former prosecutor and attorney here in the Valley, Josh Colesrud. Excuse me, Josh. Are you there, Josh? Can you hear me?
Yes.
Okay. Thanks for holding on for us. So what were your takeaways today? I know you and I briefly talked about how the defense tried to poke holes in this opening statement. Where are you at with that? I mean, is the DNA the big elephant in the room in this, or is the circumstantial evidence matter? Where are you at?
Well, I agree with what Judge McDonald said. However, you know, DNA is always circumstantial evidence. It's never direct evidence of a crime, meaning that it doesn't tell you the method, means, or opportunity of how the crime took place. So in this case, it's not going to tell you exactly how the murder took place or when it took place or even who committed the murder. Again, all it's telling you is that the defendant in this case has his DNA at a location where the murder did take place, right? However, you know, that only tells us a part of the story. Now, what the defense is doing here is they're saying, look, we're not contesting what the criminalist is saying. Yes, that's our client's DNA. We accept that. We will contest why it's there, but we're not saying it's not us. What we are saying is not only did we not commit the murder, but we have a good idea about who committed the murder. Now, as Judge McDonald said, you know, it's a difficult defense. It's called a third-party defense, where the defense is basically turning into a prosecutor saying who did the crime. So they're going to have to show by method, means, and opportunity why the pharmacist in this case is the most likely killer. Now, the defense doesn't have to prove beyond a reasonable doubt that the pharmacist did this, okay? But they do have to prove by affirmatively showing that there's enough evidence that somebody else did this, and most likely that it was the pharmacist to create the mythical reasonable doubt, which is what they need.
Josh, I want to ask you real quick, just to cut to the chase. Do you foresee the defense team subpoenaing this pharmacist to come and testify and to get on the stand and to explain themselves?
Well, if they do so, it'll likely just be for show, because if you're the pharmacist, there's no reason for you to not plead the fifth. I mean, even if you had nothing to do with the murder. There's plenty of people that have gone through the criminal justice system that didn't commit the crime that were prosecuted. And if for some small reason the prosecution believes that the pharmacist did this, I mean, there's always the possibility that they dismiss the case and then charge the pharmacist. So if you're the pharmacist's attorney, I think that it would be malpractice for you not to plead the fifth if there's any inclination whatsoever that you could be blamed for this, even if you had nothing to do with it. If a reasonable person could be like, that's interesting. Why is your DNA there? Or is it possible that you had a motive? Like, you don't want your client being put in a situation where his statements could later be used against him. And not only that, but his statements could be used against him civilly as well. So if the victim's family later sues both the defendant in this case, they could also sue the pharmacist jointly or severally for the death of their daughter. So you want to keep his lips as tight shut as possible.
Josh, on the other end, I mean, can a defense attorney in a high-profile murder case just pick a name out of a hat because it has some sort of relevance or relativity to this case and start throwing my name around just because I work at the pharmacy down the street? Could he sue them in return?
Well, as the judge said earlier, there has to be a good faith basis for any defense. In fact, because it's listed as an affirmative defense, you have to have what's called a prima facie showing. There has to be some evidence that you can put forward that supports your theory of the case. And if you don't have that evidence and you try to put something in front of a jury, the prosecutor is going to hammer you in closing arguments, and it's going to be one of the quickest verdicts in state history. So you have to have some evidence. Otherwise, it's going to work against you so fast and be so detrimental to your client.
Judge Mel, I wanted to bring you back in if we could real quick, just for your take with, this mystery man pharmacist. I know that you had alluded to it before, but just in a response with what Josh was laying out there as a possible strategy.
Well, Josh has an outstanding point. If this guy takes the witness stand, is called by the defense, and would take the Fifth Amendment privilege against self-incrimination, that would be a huge plus for the defense, because jurors are then going to think, well, why is the pharmacist not answering the questions? Why is he taking the fifth?
Can you expound on what he was saying there, Josh? Did you hear that?
Yeah, and the judge made a good ancillary point, which is that the presentation of somebody pleading the fifth is tremendous in a third-party defense. Now, juries are instructed that you can't take someone's Fifth Amendment right and use that against them, right? But that's not what they're doing here, because the pharmacist isn't the one on trial. So they can take some sort of negative inference from the fact that he is pleading the fifth. Now, we don't know yet that that's what's going to happen. I'll just tell you that if I was the pharmacist's defense attorney, I would be telling him that he absolutely has to plead the fifth, because anything that he says could later be used against him. So in order to have an affirmative defense, that is where the defense has to put forward some evidence. Again, we call that a prima facie showing. There has to be some evidence that supports your theory. For example, if a defense is self-defense, that's, again, an affirmative defense where the defense actually must prove by prima facie showing. That means there's some evidence that there was a self-defense. Here, it's the same thing. So it's not like you're just trying to confuse the issues, okay? It is, you have a defense that is defensible, that there is evidence that supports what you're saying. And a judge actually has to make that determination. Okay, so in this case, you would expect the defense either through cross-examination of the prosecution's witnesses, or by presenting evidence through their own witnesses. The judge would have to determine before it goes to the jury whether or not the defense has made the requisite showing of an affirmative defense. And then the burden shifts back to the prosecutor, where the prosecution has to prove that it didn't happen. It's a little confusing,
Wow.
but the defense can't just make up a defense to confuse the issues in any way whatsoever. There has to be something that moves it across the starting line to support the theory.
I would wonder then, forgive me if I'm asking what you just answered, but we asked the judge before this, did the prosecution know this was likely coming? And if so, why didn't they go to the judge before any of this started and say, you can't bring up this guy.
Right.
There's no evidence. There's no this, no that. You can't bring him up at all. But that apparently that didn't happen that way.
So the discovery rules are the same for both sides, meaning that the defense has to disclose any and all evidence that it intends on using at trial no later than 20 days before trial. Otherwise, there can be sanctions against the defense, which could include the preclusion of the defense itself, preclusion of evidence, or the continuance of the case. Now, if you're a prosecutor and you receive this information today for the first time, now, you're going to be crying bloody murder. And if you don't like the jury pool, you're going to be demanding a continuance, which will be granted every single time. So I suspect that the defense gave notice to the prosecutor that this was going to happen well in advance of trial. Again, the discovery rules are the same. The defense is obligated through Rule 15.2 to disclose any and all evidence that it intends to use at trial, in particular to affirmative defenses, which has their own special set of evidentiary rules, which requires advance notice before trial. So I don't think there's any doubt that the prosecutor knew about this before today.
Wow. As we were trying to get the judge back on, Josh, while we have you, anything you're looking for as we move forward today? It sounds like we're going to get our first unidentified witness here any minute now. Any thoughts what might be heading our way?
Well, I think what we do know is what the prosecutor is going to do in this case. But what's still a little bit of a mystery is how the defense is going to try to pin everything on the pharmacist. They gave a little bit of a window about that in their opening statement, but I want to know how they're going to prove it. Which witnesses are going to use, which pieces of evidence they think are important for the jurors to understand and consider. So I'm really more interested in what the defense is going to do, only because it's unknown much more than what the prosecutor is going to do. What prosecutors do is, very obvious to everybody. There's no hiding the ball. We all know exactly what the prosecutor thinks what happened because it's in the indictment and in the discovery as well. So there's no surprise at trial from the prosecutor. It's the defense attorneys that have to think outside the box. And hopefully in this case, they'll put on something that is memorable, especially if their client didn't do this.
That's why they get paid the big bucks.
For sure. Well, I think Judge Mel McDonald's back with us. Hey, Judge, I just wanted to get your final thoughts as we're about to go back into court. But also, too, I just wanted to ask from your perspective, having led so many of these cases where we had the juror appear to fall asleep, how much of a challenge is that in court? And how do you navigate that without potential problems going in the future? This is day one, of course.
That's typically why you have alternates. So if you have concern about a juror being able to function, that's precisely why in a lengthy case, you may have 3 or 4 alternates. You just draw one of the alternates by lot. But one other point that I wanted to raise with this defense, I think if you're the prosecutor in this case, it could be devastating consequences if this pharmacist goes on the witness stand, takes the Fifth Amendment as part of a defense case. You can take it to the bank that the prosecutor and the police have thoroughly investigated this guy, run DNA, checked alibis, everything else. and would have assurances to him that nothing is going to happen. They could work out some kind of an agreement or understanding, because they wouldn't be charging with murder if they thought there was any possibility. And whatever evidence they've got, they would lay out to his attorney and advise him, you've got to testify, we need your testimony. The inference of you remaining silent would be devastating. And that could very likely create reasonable doubt in one or more jurors' minds. So I would be shocked if by the end of the case, the defense puts him on, he takes the Fifth Amendment, and the prosecutor hasn't worked out some agreement with him to make sure that doesn't happen.
All right. Looks like we're taking a little bit of a break in this murder trial, day 2, and it was cross-examination day for the boyfriend. What was your take on his demeanor? I wouldn't call him difficult, but he certainly wasn't giving anything more than they asked.
I think you're exactly right. Yeah. I mean, I feel like the prosecution had talked to him ahead of time, a little bit of coaching of,
sure,
hey, here's how we need to answer the questions that could be happening, and had a little bit of strategy coming in. But I thought it was interesting, too, with the prosecution and how they were setting up, talking about a few things that maybe possibly that they saw as pitfalls in the future, with some cash that was missing on a trip to Europe and Paris, and then getting straight to the heart of the matter with what the defense was claiming about this Walgreens employee. Did Allison have any recollection of meeting this person or knowing them? Had it ever come up in a conversation? To which he emphatically said, like, no, I have no idea who this guy is, because they named him repeatedly in court again. So that was interesting. But
they seem to be picking apart their relationship a little bit, or wanting to know how close they were or were not a little bit. Maybe they're lining up something that
you mean the defense attorney when
the
during
defense attorney asking the boyfriend, about how tall the back wall was, how if you could see both cars when you entered the back gate, which door did she use, and
a lot on security too. Did you encourage
security? So they may be lining up how close or not close their relationship was. We assume to get back to the pharmacist as another possible love interest, do we think?
Right. Because one of the things that was mentioned earlier, and I believe this was actually last month too, when they were introducing the witness list and, who they wanted to call on, were part of the basis with this pharmacy employee was that he may or may not have, the defense was claiming, viewed Allison's dating profile as part of it. So I can only assume that might be one thing that they want to circle back on. But let's bring in retired Maricopa County Superior Court Judge Mel McDonald. Judge Mel, so great to have you again, sir. And I know you've been listening along with the testimony in court today from the witness, but what's your overall take, Judge?
Yeah, I think it's going as I would expect. One of the things that the prosecutor is seeking to do is, in cases like this, the first person that you look to, if you're an investigator, is those closest, which would obviously be the boyfriend, friends, neighbors. Then you go to the next level, known predators that may be in the area, and you gradually expand out. Well, the defense is trying to create reasonable doubt. So what a prosecutor does is lay out through the key witness, the boyfriend, the information to show that they're to exclude him from any consideration. So when the jury considers the DNA and other evidence, that they've got a feel for what the police have done. It's important to note the time and hours they spent with this boyfriend, trying to make sure and to let the jury know. They spent hours, days, repeated interviews to absolutely dot all the I's and cross the T's to make sure that the jury understand that there was no conceivable way he was involved.
Judge, we should bring up that, this man is a victim too. He lost a loved one. He had to find the body. He said it took a giant toll on his relationships, both personally and professionally, to the extent that he had to change his name. So I just wanted to bring that up, that this guy's been through hell along the past 11 years. Judge, could I just get your thoughts? What were they going for, do you think, about this trip to Paris and the alleged missing money and the Chanel purse? I kind of got lost on that a little bit. Do you have any hunches on where they were headed there?
Again, I think what you do if you're the defense attorney is anything. I mean, what we have in this case is part of the criminal act itself, is missing money, missing items. And so what you're going to try to do is to interject into the case anything you can which might offer some kind of an explanation. And I think what they are trying to do, what the prosecutor does, is anticipate where the defendant's attorney is going to go. And then what the defense attorney does is pick out any areas of doubt that might explain away or focus attention away from the client.
Judge Bell, I wanted to ask you too, Brian and I were discussing just I know that you were also a prosecutor for a number of years, but can you talk about just how you thread that tightrope that can happen where you have somebody that, it seems like he certainly has been a victim of this crime as well. He mentioned about the emotional toll that this took on him with his personal relationships, his professional relationships, and even having to change his name. But as a prosecutor coming in to where you still want to poke holes in the case, but the defense attorney having to go in and poke holes in the prosecution's case, but you don't want to come off as, being too aggressive with the witness because potentially they've been a victim of the crime. How is that tightrope with walking that?
Yeah, interesting enough, and one of the things that captured my focus was the defense attorney trying to name this pharmacy employee as the actual perpetrator. What you now have in this case is literally three victims: the deceased, Miss Feldman, the boyfriend, and now the pharmacist. And as a former prosecutor and former United States attorney, what jumped into my mind is if I was prosecuting that case, I would make major issues of this. In the closing argument, I would make absolutely certain that this pharmacist is prepared, that there are assurances given that he is not a target, has never been a target. He is a victim. And what you have, if I were prosecuting and making that argument at the end of the case to the jury, would point out that there's, as horrible as Ms. Feldman was as a victim in this case, the pharmacist employee is himself a victim. The boyfriend is a victim. And in my heart of hearts, I think it would have been more effective if the defense attorney had not tried to identify anybody, but just listed as possibilities. By pointing the finger at somebody else, he opened the door for the prosecutor to say, this defendant now not only has a murder victim, but they're now going after innocent people.
And Judge, how can they do that? How is that even legal? I mean, if this guy had nothing to do with anything and he's being outed in open court, his name tossed around, I mean, why wouldn't the judge at least not allow this to happen before it did?
Well, there's ways you can move this. A prosecutor can move for what they call a motion in limine to preclude evidence in the case. I would add, though, that this is a death penalty eligible case. And on those kinds of cases, the appeals go on. If he received a death sentence at the end of the case, he's going to be 20 years before it happens. And they will go through endless appeals through the state courts, through the federal courts, trying petitions to the United States Supreme Court. So you've got to make absolutely certain that you don't enter rulings that are going to limit or later prove to be erroneous. So in cases of this magnitude, I think the courts are going to give the defense counsel broad latitude in his questioning, and they're going to allow him. When you make that claim, you better have some pretty good ammunition, because I think this could potentially really, really anger jurors to think it's bad enough for the family of Miss Feldman, her parents and other siblings, and her fiance to go through, but this poor pharmacy employee to be told that he's convicted of murder and to have to live with that kind of claim, allegation that will follow him forever, I think is horrendous. I could foresee him at some point saying, I'm going to sue that guy, the attorney, for the damage he's done to my reputation. Anybody that knows him and follows the case, they're not going to hear his name from your broadcast. But that has scarred him for the rest of his life. Even if this guy is convicted, people are not going to forget that he was named and accused of murdering this wonderful young woman.
Absolutely right. And can I ask you, Judge, along those lines, Trenton and I were pontificating why the defense seemed to be picking apart the relationship between Allison and her boyfriend, fiance. What's you think's behind that? Are they trying to show that maybe they weren't as close as he portrays, and so that maybe there was room for other guys in her life, like a pharmacy employee?
I think that's precisely where they're going. What they're trying to do is to pick any thread that they can possibly pick out that would linger in a juror's mind. And you've got his description of the wonderful, close, loving relationship that the two have shared, that the dining out and the moments and the experiences what they've shared together. What they're obviously, the defense is trying to do is to undermine the strength of that relationship. And again, I think suggest that Ms. Feldman wasn't who the state is suggesting she is, that there was probably room for others in her life, that possibly she was reaching out to this pharmacy employee. And these are, again, are threads that they're trying to put into the case that at some point, which will be the closing argument when they lay it out, trying to show that there's reasonable doubt that this victim's boyfriend was not on such solid ground as he was, that Allison may not have been the devoted girlfriend to him, and that this pharmacist, probably jealous of this relationship, decided to take fatal action against her.
Judge, I want to ask you too. We were chatting a little bit last night, but I know yesterday we had a little bit of technical difficulties to get your answer in, but I do want to do that. One of the other attorneys we had join us had mentioned the possibility if the defense calls this pharmacy employee to the stand, and then the potential for them, pleading the fifth on their testimony and not to incriminate. But I know that you had a very emphatic take that the prosecution would not let that happen, just the risk of a hung jury and any potential damage. If you could share about that.
Yeah, I've had the good fortune of being on all three ends. I've been a prosecutor for 4 years, U.S. attorney for 4 years, judge for 7 years, defense attorney for 37 years. So I am well aware and if I was the prosecutor in this case, that pharmacist would testify. And if I was the defense attorney representing the pharmacist, I would make sure before that testimony is handed down that the state has already made clear that that pharmacist is not a suspect, never has been a suspect. They believe and have indicted and are pursuing somebody else for this murder. That pharmacist is vital, because if the pharmacist did not testify, especially if he took the stand and invoked the Fifth Amendment privilege against self-incrimination. And they left it at that. If you're sitting on that jury, you're going to think, wow, why is that guy taking the fifth when his reputation has been destroyed? Why is he doing that? There is no way, if I was a defense attorney, I would make sure that my client had sufficient protection so that if somebody down the road changed their mind, that there are non-prosecution agreements, but there is no way that witness is not going to testify if you're the prosecutor. That's going to happen. And if the defense doesn't call her, I'm going to call her.
Hey, Judge, at the beginning of the day, the defense attorney started off complaining about the courtroom itself, the size of it, the technology. What's your take on all that? He wants to go to a different room that he thinks would be better suited.
Again, I was at another appointment this morning and didn't hear that. What you need to remember in cases, particularly capital cases, it is critical to create a record. Anything you might possibly have down the road is an appeal. And in this case, we have the DNA draw. We have the vial from the DUI case, challenges to the search. What you're trying to do is to put in that record everything that you possibly can that some court someday might point a finger to in an appeal to set aside, especially if there would be a death sentence or some basis. I think what they're trying to do is to create a record. I can't conceive of how the size of the courtroom or the appearance of the courtroom should make a difference. From my days on the bench, I started out with one of the worst courtrooms in the courthouse. I would sit in the chambers, the jury would deliberate in the courtroom, and there was a mighty thin door. And I thought, whoever designed this had to be smoking too much marijuana. but the bottom line is that's not a basis for an appeal, but I can see them, maybe they want a bigger courtroom, maybe a little bit more grandeur in the setting, but they try to create a record in anything they can put that might reach some point someday they can make it.
And Judge, just a little more, if we could touch on the defense was really trying to make the case that we do not want the press involved in this trial whatsoever. And then the complaints that they had with the camera setup, that there might have been some things that were shown on screens that you could see. Although just my watching our pool camera feed that we have in there, just with the focus of where it was at, it's really difficult to see much of anything except for where it's directed. But can you talk about just the judge's perspective of hearing that, and then also making the decision with the public's right to know of a case of this much attention?
Well, the best part would be that my face is in the courtroom, so that would prejudice everybody. Bottom line is what they're trying to do is, again, create a record, anything they can do. Pretrial publicity. One of the great constitutional protections we have in this country is the press. And I think this judge is making extraordinary efforts to accommodate any concerns they have. The delayed feed. During my days on the bench, we don't have the sophistication and the cameras and the setups, but I tried cases during my defense attorney days where you'd have cameras literally in the courtroom. One time I had Dateline 48 Hours in 2020. All those cameras are going, and you don't like it, and you try to perhaps create a record. This is what they're trying to do. There are extraordinary protections for this defendant in this case. The delayed broadcasts, what you can show and not show, protecting witnesses if they don't want to be identified, blurred. As you pointed out, you're not identifying the name of the pharmacist. These are all extraordinary protections. If you're the defense attorney, you're trying to make a record. You're trying to say anything that some appellate court someday may try to hang their finger on in an appeal. So I applaud them for doing it. I think it's wise and prudent. If you're a defense attorney and you're dealing with a capital case, you want to put every objection you possibly can in the record that has some feasibility, some argument, and media coverage and pretrial publicity, all of that during trial publicity are relevant issues. And what they're trying to do is to protect the record.
Judge, if I can, before we let you go, can I put you a little bit on the spot here? I know it's only day 2. Based on what you've heard so far, what is this going to come down to?
I think it's going to come down to the 3 magic letters, DNA. The DNA is crushing evidence. I look back at my days as a prosecutor in the 70s. What a blessing DNA would have been. I had major serial sex offender cases where victims were there. They didn't have DNA back then. In the juror's mind, if you watch these forensic file cases, DNA is the key. They're going to take the bits and pieces, the deposits of the banks, the payoffs, the proximity of the vehicle in the area. These are all pieces that go into the puzzle, but the key line in the puzzle, and that's why they fought so hard to exclude the DNA, is the DNA. And the DNA links this defendant to the scene, and they've already got him making statements that he wasn't there, he wasn't in the area, et cetera, et cetera.
Judge Mel McDonald, if you want to hang with us, we're actually going to go back to court. They're about to resume, and I believe we have the next witness coming in, one of the Scottsdale police officers that responded to the scene. So appreciate your analysis, always poignant. So let's go back to court and listen in if we can.
Thank you. Good talking to you.
Thank you, sir.